Welcome to the PI Show. My name's Harry Nowicki. I'm a personal injury lawyer. I'm here together with my colleague Tony Carbone, who's also a personal injury lawyer.
Good evening, viewers. Good evening, Harry.
It's down to the two of us, and
That's good.
It's a show that we can talk about the changes to the Accident Compact in Victoria. There's been significant amendments.
There's been some good ones, Harry. Some
and that
interesting
affects
ones.
all people who work in Victoria and their rights and entitlements. But before that, we can talk about a recent Court of Appeal case decided by the Chief Judge and two other judges about what is a significant area of dispute, which is
Serious injury. What is a serious injury under the Accident Compensation Act? But the beauty of this case,
why
Harry,
is that important, Tony?
well, it opens a gateway to being able to sue someone for damages, that is for pain and suffering and loss of enjoyment of life,
So if you don't have
and
a
also
serious,
loss of income.
if the judge says you've got no serious injury,
Well, you can't sue.
you can't sue.
No.
So that eliminates a lot of people in Victoria who have injuries but can't sue.
That's correct. You know,
And-
they might have other rights to impairment benefits.
No fault
Which-
benefits.
That's correct. Where the amount of, your disability doesn't have to be as high. The bar's lower. Yeah.
But if you've got a serious injury, you then can sue your employer, and
Or a third party, depending on who's at fault.
the courts, if the Victorian Work Cover Authority don't agree you've got a serious injury, then you've got to go to court.
Then you've got to commence proceedings and get a judge to determine the issue. But do you know what I like about this case? I mean, it tries to brings it back to grassroots level in terms of what serious injury means. You know, they finally tried to.
Well, the Chief Judge says that he has reviewed, I think, 8 cases of the Court of Appeal
Yes.
that have been heard between 2006 and 2009, and he's tried to bring out some common themes.
Yeah, look, the most significant thing about it is he says pain, which most people do experience when they've been injured, is a very important factor in determining whether someone's got a serious injury. And that will be borne out once we go through the facts of this particular case.
Yeah, look, I think the facts are important. Mr. McKinnon is a 62-year-old who was a rigger, suffered an injury on a building site on the 30th of November 1999,
That's correct.
and he finally got to court in 2009, I think.
Geez, that's a long time.
10 years after the injury.
That is a long time.
So the judge had to decide. I think he suffered a right ankle injury.
It's a nasty ankle injury.
And in 2009, the judge had to decide whether Mr. McKinnon had a serious injury or not for pain and suffering, because he had a property in Euroa. He went back to Euroa and got a job at a Lindsay Stud working for Peter Hayes.
He was working for the Peter Hayes' racing stables. But
And he was there as a handyman maintenance person. A big stud property, 1,400 acres, and he was working there on a daily basis, so he can't claim any financial loss.
just prior to that, Harry, he'd gone back to his old rigging job doing 2 hours a day for 5 days, but had to give it away in the end. So that's where he got the other job.
So he got a job with Peter Hayes, the horse trainer, and then has kept working. So can't
That's
claim
correct.
economic loss.
No, can't claim loss of income.
So judge had to decide whether his ankle injury was
Satisfied the test of serious injury.
whether it was a serious injury or not.
That's correct.
What did the judge decide, Tony?
Well, the judges looked at the facts of this case. They basically stripped it back and looked at what he was experiencing on a day-to-day basis, how it affected his ability to work. He says he had to stop on regular intervals, 4 or 5 times a day for 5 to 10 minutes to rest, medication, problems sleeping. He actually just went through everything that
Day-to-day
was
living.
interfering, with his
Day-to-day
day-to-day
living.
activities and living. And they came to the conclusion that, guys, he's got pain. That's the words they use. And they were satisfied that pain constituted serious for the purpose of the definition of serious injury under the Accident Compact.
So the judge in the first instance said he had a pain and suffering certificate.
That's correct.
And then the Work Cover Authority appealed that, and three judges in the Court of Appeal agreed with the
Principal judge.
primary judge that he had a pain and suffering injury. And I think the Chief Judge took it upon himself to ask for the barristers in the case, can you help the court in setting some guidelines?
Yes.
But the barristers, quite rightly, I think, said each case is different.
It is different. I mean, every case is different, but for the first time, someone's actually said, look, what is it we're talking about here? We're talking about someone that was more or less pristine prior to the accident. No one's ever 100%. You don't kid yourself. People have got high blood pressure problems. They've got aches and pains from playing football and soccer and tennis and all sorts of sports when they were younger. They might be migraine sufferers. They might have cholesterol problems. But bottom line, this fellow, what changed in his life was the fact that
The right ankle injury.
the ankle was there. At night time, he had problems. During the day, he had to take rest breaks. He needed medication.
His medication wasn't much. It was there's an argument about whether it was prescription or non-prescription medication.
It probably doesn't matter because a lot of people, depending on their own body, can't take prescription medication.
But he was stoic. He I think the court arrived at the conclusion he was a fairly stoic individual. He got on with life, but they still said he had a serious injury.
That's exactly right.
I think it was a fair decision. We're not quite sure what the quantum was because I think it's a gateway and then they've got to look at the issue of negligence.
Well, if they were fighting the issue of serious, you can bet your bottom dollar they wouldn't be offering him too much money, Harry. So that could be another dispute down the
There's
track.
another dispute. But look, the court said you've got to look at, I think they indicated people's injuries and the effect on sleep, mobility, their capacity for self-care and management, performing household family duties,
And
recreational activities, social, sexual life,
Well, that's important.
and enjoyment of life.
What the defendant tried to harp on the fact that he went back to full-time employment, but the court said that that's only one of the issues you've got to look at. It's just one of the factors.
Yeah.
It's
yeah,
not the
yeah.
be-all and
They
end-all.
They highlighted, in my opinion, quite rightly, the pain that he went through on a daily basis.
And mind you, by the time he got to court, it'd been 9 to 10 years. And it was constant. So it would have made it a lot easier for a court to come up with the determination that they
But
did.
it could have gone either way, Tony.
Harry, we've got to go to a sponsors break. I'm just getting the producers here. Look, don't go away. Stay tuned. We're going to a sponsors break. So we'll be back very, very shortly. Thank you.